Yeah.
Okay, so I'm going to start speaking a little bit about a very interesting, very creative legal concept called the Alien Tort Claims Act. It was created, it was passed, is based on a law passed in 1789 in the United States, in a very new United States. As most of you know, it got independence in 1776. It allowed foreign nationals and US citizens to sue a foreign national in for crimes committed outside of the United States. So anybody can sue a foreign individual for something that happened in another country. It has become the main tool to prosecute in US courts the violations of human rights committed abroad. The Alien Tort Claims Act is referred to in the acronym ATCA, was established, was passed as part of the organization of the US federal court system. So it allowed US federal courts to have jurisdiction over any civil action brought by an alien. And now when I'm going to be using the word alien, I'm referring to a foreign national, so not a US citizen, or to bring a claim in a US court for a violation of international law. So any human rights violation, UN conventions, or a US treaty. So many treaties in the United States are actually just signatories when the US signed on through a treaty to a UN convention. So it is a tort. It is a claim for a tort action. And many of you are not lawyers. So I'll just explain very simply, a tort is just a damage. So a personal damage, that can be an injury to an individual, murder, the death of somebody. So it allows you, torts allow you to sue for money. So a decision that is passed under the Alien Torts Claim Act will result in a financial reward. So you'll be able to get money for suing a foreign national in a US court. It was rarely used for 2 centuries after it was passed. Its exact purpose and scope remain debated, but according to the US Supreme Court, the Act's primary purpose was to promote harmony in international relations by ensuring that foreign plaintiffs have a remedy for international law violations in circumstances where the absence of such a remedy might provoke foreign nationals to hold the US accountable. So since 1980, courts have generally interpreted the statute to allow foreign nationals to seek remedies in US courts for human rights violations committed outside the United States. Beginning in 1980, it was used as the basis of suits against individuals. And in the 1990s, something very interesting happens, and it starts to be used by US and international individuals to sue for corporate crimes. So for example, if a US company leaks, or US British Petroleum, any company, US or international, leaks oil in India, or there's a gas leak in India, you can sue under the Alien Tort Claims Act. And before we begin to discuss this, US courts have been very generous in allowing foreign nationals to sue when the claim is for human rights violation. That is not true concerning corporate actions. US courts have been very restrictive, and almost every time that claims against corporations have gone before the Supreme Court, they've been rejected. So that's something to keep in mind. If you are working on examining a case against an individual in Russia, or a member of the government in Russia, you are more likely to succeed than if you are looking to bring a claim against a corporation, be it international, be it, for example, US corporation is involved and is funding different activities in Russia, that claim is going to be harder to pursue. And it's very debated and very upsetting to human rights lawyers that the US courts are refusing to hold corporations as accountable as they're allowing the courts to hold individuals accountable. So in 1980, the Court of Appeals for the Second Circuit in the United States was presented with a case, it's called Filartiga versus Peña Irala, that the ACTA could be used to sue a Paraguayan officer for acts of torture that he committed in Paraguay. The well-established universal prohibition of torture under international law, the court held that must be honored by US courts, regardless of the nationality of the victim or the perpetrator. So you have a case where a victim from Paraguay is suing a Paraguayan police officer in the United States. And because the US is signatory to the torture Convention Against Torture, and it is a universal crime to commit torture under treaty law that US is signed to, you are allowed to do that. You are allowed to bring a case. There are no individuals involved here who are US citizens. So the one other thing to keep in mind when thinking about doing these cases and examining these cases is that you would want to partner with a United States human rights law group. For example, we're going to discuss the Marie Colvin case. I was involved in that case. It was the case of a journalist who died in Syria, supposedly under the attack of the Syrian troops. It was, but they sued the president of Syria, although those links were harder to prove. You have to, so I was working for a group called Center for Justice and Accountability, and that is basically all they do, is they work on Alien Tort Claims Acts. So as a Russian, as a African, you would go to, as from any alien coming to the United States, you would associate yourself with one of these human rights law groups. The second step for those human rights law groups is that they then partner with a large US law firm who will support and will be, for example, their lawyers will be able to take the case all the way to the Supreme Court. They'll have at least one lawyer in their firm that is a member of the Supreme Court of the United States, licensed to represent in front of the Supreme Court. So you'll have a partnership with these, with a human rights group that will then build a partnership with a law firm. So it is not just directly an alien coming into the United States and suing. It should always be going through a human rights group, then going further to an attachment through that group to a law firm. So in the case of Filartiga, the two Paraguayan citizens attached themselves to the Center for Constitutional Rights. They did not just come to a US court and start filing a lawsuit against a Paraguayan police officer. So the Center for Constitutional Rights took their claim. They met with them, they built a case, and they brought a suit against a Paraguayan former police chief who was at that time living in the United States. The importance and relevance of the person being sued being in the US, there is no, it's not necessary. The person who is being sued, it's not necessary that they're in the United States or that they're present in the United States. What is important is that they are, that's only relevant and important in terms of getting compensation. So you are able to sue anybody as long as you can serve them with papers. So knock on a prime minister's door or a member of the cabinet's door and serve them with papers saying they're being sued in the United States courts. That is important. But the second thing is, if you have that person as resident in the US, you're able to collect damages. In the other cases that we're going to discuss, when the person's not present in the US, that's not possible. It becomes sort of like a European Court of Human Rights case where, yes, you've been awarded this and it's a great victory, but will you ever be able to collect the damages becomes questionable. So it becomes more of a a theoretical victory. The plaintiffs alleged that the defendant in this case had tortured and murdered a member of their family. They asserted that the U.S. federal courts had jurisdiction over the suit under the Alien Tort Statute. The district court dismissed it first for lack of subject matter jurisdiction, holding that the law of nations does not regulate a state's treatment of its own citizens. So the first level court in the United States decided that it's not a place for a US court to be looking at what would happen in other countries. That's not the place. It was appealed to the US Court of Appeals for the Second Circuit, and it was reversed. And so the decision of the Second District Court was that the Alien Tort Statute allows jurisdiction in federal courts over a suit between two aliens, and it is a constitutional exercise of Congress's power because the law of nations has always been a part of the federal common law. So it decided that because of the essential treaties between countries and the fact that the U.S. is a signatory to torture statutes, that it is possible for two completely foreign entities to bring a suit for a crime that was also foreign, that also occurred outside of the United States. And thus the statute fell within federal jurisdiction. The court held that the contemporary law of nations had expanded to prohibit state-sanctioned torture. The court found that multilateral treaties and domestic prohibitions on torture evidenced a consistent state practice of prescribing official torture. The court similarly found that United Nations declarations, such as the UN Declaration on Human Rights, that the US is a signatory to, manifested an expectation of adherence to the prohibition of official torture. The court therefore held that the right to be free from torture has become a principle of customary international law. And customary law in the United States is a very significant part of the law. So we have things such as the law stating specifically something, but when it's been used in practice in a certain way, or when something has been used for in this case, 200 years, that's customary. It doesn't even need to be put down in words. It becomes a frequently used principle. So the principle that torture is illegal, rather than saying the US is going to use this under universal jurisdiction, which because of Henry Kissinger and a number of people who don't want to use those terms, the court found a way to say customary international law and to use the Alien Tort Statute to cover that, to allow this tradition and this universal idea of torture that the US has signed a treaty against to become into and be prosecuted in a US court. And I really want to stress that this is one of the most creative applications of US law that you're going to ever see, because this statute was made after the Revolutionary War, allowing suits by, for example, a French soldier against a British soldier in US courts, and it has now been expanded to become probably the strongest vehicle for human rights prosecutions in US courts. One of the judges on the panel hearing the Filartiga case said, and I'm going to quote now, Filartiga should not be misread or exaggerated to support sweeping assertions that all or even most international human rights norms found in the Universal Declaration or in international human rights treaties have ripened into customary international law enforceable in the domestic courts. So this one judge was trying to put a limit on what is customary law. So we have things such as theft and things that are protected in specifically stated in statute. And then you have these broader things that US treaty signatory. Universal Declaration of Human Rights puts out many, many idealistic, such as the right to an education. And I'll use that as an example. And that's something that the US has not codified. That's not been put down. So there could be an argument that the Universal Declaration of Human Rights is an idealistic examination of what human rights entail. However, something like torture, that is something that the US has consistently prohibited and punished in its courts, and that it is a treaty signatory to. So you would have to, if you were building a case in the US for crimes committed outside of the US, you would really have to look at US customary law. What is the US looking as being, what treaties has the US government signed? What cases has the US prosecuted? What has they prosecuted under normal customary law in the US, as well as through the Alien Tort Statute? Again, it's something that is not difficult. I mean, as long as you have access to Google, you could build and look at all the US cases, but it's something that you should also think of, that partnering with a US human rights group, you're gaining access to brilliant lawyers who have done these cases for years, if not decades, and who will not charge you anything. These cases are all taken by human rights groups on pro bono basis, on a pro bono basis. So, you know, at the end, if we want to discuss any cases that people would be considering hypothetically to bring to the US, it would not be hard for me to send you a list of human rights groups that are renowned for bringing claims under the Alien Tort Statute in the United States. So what was the decision in Filartiga? The US courts ruled in favor of the victims, and they awarded them roughly $10.4 million. And remember, this is 1980, so this is probably $20 million now. So the decision was, it was stated in the decision that torture is clearly a violation of the law of nations, and that the US courts did have jurisdiction over the case since the claim was lodged when both parties were inside the United States. So in this case, they did look, and we'll see in other cases where they don't look at that, but in 1980, they did look that the victim was living in the United States, and the perpetrator of the crime was also in the United States at the time. So even though they allowed for both the claimant and the perpetrator to not be US citizens, and for the crime to have occurred outside of the US, in this case, the court put an emphasis on the fact that temporarily, at that moment, both individuals were present in the US, and that they could try to enforce a judgment. One thing to also point out that could become a potential defense in any case, and was rejected in this case, is that the perpetrator, Mr. Pena, he tried to dismiss this case based on it's called forum non convenience, meaning that there's another place that this case could be brought. So their defense was these crimes occurred in Paraguay. These crimes should be heard in a Paraguayan court. So, for example, if you brought a case against Russia, it's possible that whichever individual was tried as a torturer or a criminal and was they could raise the defense that because these crimes occurred in Russia, they should be prosecuted in Russia. And so Filartiga could be used as a precedent because the court found that this was not relevant, that it was fine that both individuals, that this case could be tried in the US. And it was not essential that it be sent back to Paraguay. This jurisdiction of US courts over tort claims, so claims of damages that occurred outside of the United States, has been tried since the Filartiga case in over 20 cases successfully. This is an interesting case. I think we mentioned during the during the start of our sessions, I was a war crimes prosecutor in The Hague from end of 1994 until 2010. And this case was brought in 1995. So the ICTY was open and it was functioning, but we did not have Mr. Karadzic in detention yet. So Karadzic was still at the time representing the Republika Srpska, which is the Serbian part of Bosnia. So in acknowledging that non-state actors might be found liable under international law, Karadzic seemed to extend Filartiga, which limited individual liability to state actors. So both cases are based on the same principle. Customary international law defines not only the substantive offense, but also who may be liable for that offense. Whereas customary international law holds that only state actors are liable for torture. It provides that an individual non-state actor may be liable for offenses such as genocide and war crimes. Because Karadzic was alleged to have perpetrated both genocide and war crimes, the court sustained jurisdiction over him as a non-state actor, so as an individual. Radovan Karadzic was coming to the United States to come to a peace discussions meeting at the UN headquarters in New York. And a group of women who had been victims of rape had gotten together and worked with a human rights group in New York. And when Karadzic came to New York, he was served with papers. He was served and given notice. So that's how the case was brought into the US court system. I don't have that. I don't think I have that on the slide, unfortunately.
It mentions it, yeah, about the headquarters of United Nations and the conference, yeah.
Yeah, so that was how he was served. So the court assumed that individual rights must be vindicated under the Alien Tort Statute, regardless of an explicitly provided private right of action in international law. Karadzic followed an established practice in jurisprudence for the ATCA. Despite the historical practice of allowing suits by private individuals, the existence of a private right of action remains still a controversial matter. So this controversy could have been essentially settled by the Second Circuit, which is New York, and by demonstrating how congressional intent favors the suits by private individuals under ATCA, Karadzic might have openly implied a private right of action in the statute, laying a more solid foundation of the vindication of human rights under the ATCA. And I'm going to go to SOSA. So that's a very important element and an essential element, like I said before, is being able to serve the person with papers. So the person has to be, before anybody's brought to a lawsuit in the United States, they have to be served notice that they're being sued. Karadzic was in New York. He was there as a diplomat attending, but he was still allowed to be served papers. We'll see later in the Colvin case, they served the president of Syria papers by sending somebody from the US Embassy to the military attaché, and somebody actually went and served papers in the presidential palace in Syria. So notice of the lawsuit does not have to occur in the US. It can be done in a foreign country. And again, these cases are creative. They are open to change. They are open to interpretation. There is nothing to say that bringing a new challenge that hasn't been done in the last 20 cases that have come before the court would be impossible. And I'm not sure how many of you are aware, but our federal courts first of all, the federal prosecutors, the U.S. attorney's offices that will be bringing suits or be taking suits, they are appointed with each presidency. So our last U.S., and I'll use now Philadelphia as an example, because we have a number of cases that are brought in the courts in Philadelphia. The prosecutors are appointed, the U.S. attorney, the prosecuting for the circuit that covers this section, Eastern District of Pennsylvania, where I am, is appointed by the president. So, for example, you might have had somebody, we did have somebody appointed by President Trump who was reluctant to look at many of these cases. He was focused on prosecutions of immigration violations. So we were able to get a human rights case into a federal court by framing it in the context of it being an immigration violation, that the criminal came to the war criminal came to the U.S. He lied on his forms. And in showing that he actually was a war criminal, we brought and built an entire case on crimes that were committed in Africa. But it came in officially as an immigration case. Now, in Philadelphia and across the United States, all of the U.S. attorneys in all the different circuit courts are being replaced by Biden appointees. So you're going to find a group of people who are going to be much more open to looking and interpreting and being creative with the Alien Tort Statute. What happens in the judiciary in federal courts? Most of you have probably followed in the news that our Supreme Court has become heavily conservative because during Donald Trump's reign, when he was president, he had the chance, due to the deaths of a number of Supreme Court justices, to appoint a number of federal judges. The same thing happens on a lower level in federal courts. So here in the circuit courts of the federal of Pennsylvania, during Trump's tenure, he had appointed a conservative attorney general, and that attorney general had then appointed very conservative members to our federal courts. What will happen now is when there's a vacancy, it's going to be the appointment by a Biden appointee. So you're going to have a different shift. So it becomes really luck or just who is sitting as the U.S. attorney when these cases come up, who is sitting at the bench when these cases come up. You are going to find much more openness to taking these cases if you have a Democratic U.S. attorney and Democratic judges who are going to be judging and making decisions. So unfortunately, politics is always going to be part of judiciary in every country, and that is the same in the U.S. And that's a consideration you should have. But then again, again, as I'm restating, your best bet as a Russian NGO, as an NGO working abroad outside of the U.S., is to partner with a U.S. NGO, because they will know which court will be the most amenable and which court will have the best sort of connection to the case that you're bringing to strengthen your case. So now the first case in the U.S. courts to look at exactly how broadly, what is the scope that the Alien Tort Statute can be applied, is a case called Sosa v. Alvarez Machain, and that was brought in 2004. The plaintiff in Sosa Alvarez brought a claim under the Alien Tort Statute for arbitrary arrest and detention. Alvarez had been indicted in the United States for torturing and murdering a Drug Enforcement Administration officer. When the United States was unable to secure Alvarez's extradition, it paid a certain amount to the family. But the case of Sosa, it arose from the 1985 arrest of a man called Dr. Humberto Alvarez Machain by agents of the U.S. government, the DEA, for his alleged complicity in the torture and murder of a drug enforcement officer. So they were unable to extradite Mr. Alvarez from Mexico. So the US government hired 2 Mexican nationals to kidnap him and return him to the United States to stand trial. The suit went before the Supreme Court, which remanded the case to district court for criminal prosecution. Mr. Alvarez was acquitted. However, the Supreme Court expressed reservations about the legality of Mr. Alvarez's forcible abduction from Mexico. He was subsequently filed a number of civil actions, tort actions against the United States and against one of his kidnappers, Mr. Sosa. The U.S. District Court for the Central District of California found Sosa liable under the Alien Tort Statute for arbitrary arrest and detention, and the judgment was entered against him for $25,000. So Mr. Sosa was a Mexican who was hired by the U.S. government to kidnap and, in fact, kidnapped and tortured a Mexican national and brought him back to the United States. So the Mexican national was able to then sue another Mexican national and bring the lawsuit. And on the first court's level, was awarded $25,000. The Ninth Circuit affirmed the judgment and agreed that the ATS permits claims for human rights violations. However, there was widespread disagreement concerning the application of the ATS and dissent within the Ninth Circuit that led the Supreme Court to make a decision to review the case. So what happened when this case got to the United States Supreme Court? And this is, in fact, one of the things is that when the Alien Tort Statute is used in US courts, oftentimes it is used in such a creative way that it raises new legal issues that have never been examined before. So there is a greater likelihood in these cases of ending up before the Supreme Court than in normal cases that are brought between US individuals, normal tort claims acts. So that's something to keep in mind, that even if you begin in the US in a very low level court, you will be most likely thinking about always having as your goal, especially if you're not successful in the lower level courts, to reaching the US Supreme Court. The importance of being in the Supreme Court isn't only that it is a final decision, it is really the final decision of all US courts on what was legal, what actions, whether the actions that you're claiming against occurred in Russia, you could define their legality in a US court. And that cannot be overturned and that cannot be appealed. But it's also a matter of, similar to when cases are brought before the European Court of Human Rights, real public relations. If you've got the US Supreme Court or you've got the European Court of Human Rights deciding against a certain individual and making clear the illegality of certain actions, then that's setting a real tone by the US government, by the United States itself, clarifying that those actions were illegal. I think in some ways, the decision coming out of the US, because of the difficulty to get through the US court systems, and the fact that you're having a US court examining actions taken all over the world, almost has a greater weight than the decision by the European Court of Human Rights. Many people wouldn't agree with that, but there's no Russia, Ukraine, Croatia, Bosnia, Serbia, none of these countries that are being brought to before the US courts are signatories to anything. It is actually, the case is moving forward based on the legality or illegality of the actions taken. And that's the essential thing, that these cases are being decided on the basis of the crime. Is this crime so heinous in customary law? Is it part of a tradition of prosecuting a certain type of crime? That's really the deciding factor. Whereas with the European Court of Human Rights, cases are being, of course, as we discussed, based on their significance and their importance, they're going up to the Grand Chamber. But at the same time, they're only examining cases where you have signatories to the European Convention of Human Rights. So there's a real, I think, a real highlighting, underlining of how illegal was this action by the U.S. courts when they go forward in making decisions against foreign nationals in U.S. courts. So the issue before the court in the Sosa case was whether the Alien Tort Statute creates private causes of action for torts committed anywhere in violation of international law or treaties with the United States, or whether it's instead merely a provision that grants jurisdiction to federal courts. One amicus brief that was filed in the Sosa case argued that the ATS accords with the international law principle that obligates states to provide an effective remedy for gross human rights violations. Furthermore, the brief pointed out that the ATS is consistent with the historical trend of the United States in developing mechanisms to hold perpetrators accountable and supporting efforts to end impunity. So it looked at the ATS in a really trying to define it, really trying to set the limits of how far it can go and where does it, how far can you bring a suit? How much can you ask for? How connected does the individual have to be to the US? It emphasized the paramount importance of the ATS in light of its status as the sole judicial remedy available for mass and systematic human rights violations such as genocide and crimes against humanity. And now we'll get to the opinion of the Supreme Court and how they defined the ATS. In Sosa, the Supreme Court's opinion looked to the historical framework of the late 18th century to understand the intended purpose of the ATS when it became law in 1789. The court found that although the ATS is a jurisdictional statute, it was also intended to have a practical effect. The court concluded that it is best read as having been enacted on the understanding that the common law would provide a cause of action for a modest number of international law violations with potential for personal liability at the time. The court found that international law of the time included a narrow set of hybrid international norms, which were of particular concern because of their effect on international relations, and which we would have fallen under the purview of common law. Such norms included, and this was the list they gave, violations against ambassadors, safe conduct in piracy. However, rather than enumerating specific international norms which would give rise to cause of action, the court set forth a standard which recognized the evolving nature of international law and provided a modern framework for determining whether a tort constitutes a cause of action under the ATS. The framework incorporates 4 features that approximate the considerations used in 1789 to establish a private right of action. Number 1, universality, obligatory nature, specificity, and prudential considerations. So, although the US will not use universal jurisdiction, it is using universality of a crime as a consideration in applying the Alien Tort Statute. So is it something like torture? Is it something like genocide? Is it something like rape? So there's a number of crimes that are recognized by everybody as all nations as being wrong. Is it obligatory? Is it something that must be punished? Is it something that is specific? And the final consideration, is it wise to pursue this? And this is the most subjective of considerations, because who is it that's going to determine, is it prudential to bring and to examine the case? I think that consideration is always playing into the US courts' concerns, which have been the genesis and the root of why they do not want to use universal jurisdiction is that the US courts want to leave a place for the State Department, for diplomacy, for sanctions, for other ways of handling international crimes, and to restrict and define where they're going to use the Alien Tort Statute, and where they will use US courts to set human rights precedents. This isn't something, because it's such a vague consideration, it shouldn't make anybody in any country feel restricted in bringing their case. It is a very subjective thing that can be looked at differently by different courts, and that can be reapplied and determined by the Supreme Court. So Alien Tort Statute, and I will say this, speaking specifically in terms of claims against individuals in US courts, there is so much room for interpretation. There is so much room for growth. That is not the same as with corporations. And we're going to go forward and discuss that, but they've set strict limits. So while the Sosa case gave a framework, that framework in numerous points that the court laid out is subjective. So it's a framework that that is leaving room for cases to come forward and to keep coming into the United States courts and seeing how far can they go. Will they be able to pass their federal system, pass through the federal courts and get to the Supreme Court for a final decision? This is a new area of law. Even though this is a law from 1789, this is a new and for a long time very rarely used area of law that is just waiting basically that is just sort of being born now in this these decades and in this century. So there should not be a hesitation to meet with a human rights group in the US and creatively, constructively define your case in terms of cases that have come before, but also examine your case in where the cases haven't come before. What is new about your case? What makes your case something that maybe is calling for the US to examine it and to question these theories and legal theories and perhaps bring it all the way to the Supreme Court? So the conclusion in the Sosa court, the outcome, was that in light of the framework that the court established, the Supreme Court reversed the Ninth Circuit's decision, and it stated that Mr. Alvarez's arrest and detention did not violate any treaty with the United States, nor did the arrest and detention violate any international norm, meaning the specific universal and obligatory standard. So that was, in fact, a defeat for the human rights group that was representing Mr. Alvarez. But it can't be stated enough that the fact is that Alvarez was arrested and detained originally by Mexican nationals, but they were under the employment of the US government. So whether that it was not stated that they came into play in the decision, but that's definitely to have in minds that if US has a corporate, it's not unfortunate. The US has investors involved in a corporation that's tied to some sort of crimes. If the US, it's an agent of the US government that is being pursued under the Alien Tort Statute, that you are much less likely to get a decision in your favor, because the US is looking, although the man was, Sosa was a Mexican national, there was that consideration that he was working in his official capacity as an agent, even if unofficially, of the US government to carry out a legal US order to bring somebody, to extradite somebody to the United States. I think this might be a really good time. I'm going to move into one of the corporate cases to show sort of the limits that we have in bringing corporate lawsuits in under the Alien Tort Statute. So the next case that we're going to discuss is also one that was filed under the Alien Tort Statute. And it is called, sorry, Victor, the PowerPoint is up, yeah?
Yeah, all good.
Yeah. The case is called Kiobel versus Royal Dutch Petroleum. So the Shell Petroleum Development Company in Nigeria operated oil production facilities in an area called Ogunland. Esther Kiobel and other petitioners were Nigerian nationals who alleged that they or their relatives were killed, tortured, unlawfully detained, deprived of their property, and forced into exile by the Nigerian government. The petitioners maintain that the respondents, including the Shell Petroleum Development Company, were complicit with the Nigerian government's human rights abuses. The petitioners filed a punitive class action against the respondents under the Alien Tort Statute in the U.S. District Court for Southern District of New York. The district court dismissed claims against the corporate defendants in part and certified its order for interlocutory appeal. So it was allowed to appeal. The issues were, number one, under the Alien Tort Statute, are corporations immune from tort liability for violations of the law of nations such as torture, extrajudicial executions, or genocide? So up until now, the U.S. was looking at applications of the ATS under against individuals, individual torture, numerous cases of that. But this is a case that looks at a corporation. Number two, upon re-argument, does the Alien Tort Statute allow courts to recognize a cause of action for violations of the law of nations occurring within the territory of a sovereign other than the United States? So this is what the Supreme Court decided. The court held that under the Alien Tort Statute, there is a presumption against extraterritorial application of U.S. law. This presumption, derived from traditional canon of interpretation, serves to protect against clashes between U.S. law and the laws of other nations. The court reasoned that nothing within the text, history, or purpose of the statute indicates that it was intended to apply extraterritorially. In order to rebut this presumption, the petitioner's claim would have to touch and concern the territory of the United States with sufficient force. Since the statute is presumed not to apply, the court did not address the question of whether corporations are immune from tort liability for violations of the law of nations. So in this case, very unfortunately, one of the things that, and numerous cases after, there's been this reluctance of the court to apply the Alien Tort Statute on corporations, as well as a reluctance to define that they're doing that. You're going to get cases that go forward for human rights abuses against an individual that are passed, and it's found that there is a sufficient interest, a national interest. But when it is applied against a corporation, there's always a reluctance. This is extremely unfortunate, and it's unfortunate that the court will use other reasoning and rationale to limit cases against corporations. But I think one of the reasons that it is seen as that is because in the US as well, there is this liability of a corporation that is making money, that is producing, that they do not want to restrict, that they do not want the courts coming in directly to restrict. However, if something like this had happened to in the US, even in the US, it's difficult to bring claims. There was a recent claim against Chevron, where the lawyer suing Chevron, in fact, was detained and arrested for his defense of them, for his prosecution of them. So it's an unfortunate thing, and it's something to consider, that if you were looking at going after a US corporation for its involvement and for its encouragement of anything illegal in Russia, you're better off looking specifically at things like Magnitsky Act, looking at specific laws that could work for you, because it's almost guaranteed that the Alien Tort Statute will not be looked at as the proper legal tool to pursue a corporation. So several alien, meaning foreign individuals, were injured, kidnapped, or killed by terrorists in attacks against Israeli citizens overseas. The surviving families of those people who perished in the attacks accused Arab Bank, a bank corporation headquartered in Jordan, of financing, facilitating various terrorist organizations involved in the attacks. The survivors sued the bank in New York federal court under the Alien Tort Statute, which provides for federal district court jurisdiction over civil actions brought by aliens. The Arab Bank moved to dismiss the ATS claim under the U.S. Court of Appeals decision in Kyobo v. Dutch Petroleum, the case we just looked at, in saying that because in that case, the appellate court had held that the ATS does not authorize claims against foreign corporations. The district court acknowledged that because the US Supreme Court affirmed Kyobo on other grounds and had not addressed, so their way to be tricky and not discuss the protection of corporations worked against them in this Jesner case, because the US Supreme Court affirmed that on these grounds, because they did not address corporate liability, the Court of Appeals was still controlling precedent, and therefore they dismissed the ATS claim. On appeal, the court noted that the Supreme Court's decision did cast some doubt on corporate liability. However, because the Supreme Court had not addressed the question of corporate liability, the appellate court affirmed the lower court's dismissal. So does the Alien Tort Statute prohibit liability by corporations? The Alien Tort Statute does not permit lawsuits against corporations. Justice Anthony Kennedy authored the opinion in this case. He found that the original purpose of the ATS was to ensure that federal courts of the United States were available venues for foreign nationals alleging violations of international law, and thereby to stage potential foreign relations issues. The court reasoned that in this case, to allow the lawsuit to proceed would have the opposite effect. It would strain diplomatic relations with Jordan. If Congress wants to allow for lawsuits against foreign corporations, Congress should explicitly do so. So again, this is the final underlining, striking out that they do not want to use the Alien Tort Statute against a corporation. It's really meant to be a tool for an individual to sue an individual. So as one of you guys questioned, like a Russian example, if it was an international corporation that was funding certain activities that were harming citizens or resulting in torture or death, a better way to go through that is to look at the actual individual who's committing the torture, or an individual who's ordering the torture, to focus on that rather than the source of funding. And as I said before, if you want to focus on the source of funding, if you think that the case is strong, then do not use the Alien Tort Statute. Look at the Magnitsky Act. Look at, I can go through different tools that you can use in US law, specifically geared towards Russian cases that would make it easier. This is really, if you want to keep in mind, the Paraguayan case, which established it for the first time, really is a case of somebody being detained in a prison, detained by a government, being shot by, by military forces that belong to a specific government. That's where these cases belong. That's the fact pattern that you want to be looking at for these cases, not a large corporation funding violations of human rights. In the same case, Justice Neil Gorsuch, who was a Trump appointee, a very, very actually brilliant Supreme Court judge, he wrote a concurrence in which he concluded that there are two additional reasons to dismiss the suit. He said that the Alien Tort Statute is a jurisdictional statute that does not create a new cause of action, and that federal courts should require a domestic defendant before hearing a lawsuit under the ATS. So this was an attempt, and remember, this is a concurrent, so this is not part of the official claim. But now keep in mind that this is an attempt which shows the most likely direction that a conservative court will take towards the Alien Tort Statute. They want a connection by one of the defendants, or of a defendant, or of a victim, or a defendant to the U.S. They're looking for somebody who is a resident in the U.S. to be filing this. They don't like the idea, which has been allowed up until now, of a Paraguayan, of a Mexican coming into a U.S. court and pursuing this. So there's something to keep in mind, that if this does reach, if a case that you pursued as a foreign national against a foreign government or a foreign individual did reach the Supreme Court, at the moment you're sitting with a very conservative court that will have a reluctance to give you a reward, an award that you would be seeking. So that's unfortunate, but what's good about this concurrence of his is that we see the thinking, we see that the direction that the court could potentially be taking in these cases. So the dissenting opinion was written by a Democratic appointee on the court, Justice Sonia Sotomayor. She argued with Ruth Bader Ginsburg and Stephen Breyer and Elena Kagan that the text, history, purpose of the ATS support the conclusion that corporations may be sued under the law, and that the court's decision absolves corporations of responsibility for egregious human rights abuses. So now you see the completely opposite pool by the democratically appointed members of the Supreme Court, where they're supporting claims against corporations under the Alien Tort Statute, and they are obviously very supportive of foreign nationals bringing foreign claims in U.S. courts. So if, everything here is a time game. If you brought a case at the end of next year in a U.S. court, and the Supreme Court, through different justices disappearing, it would, first of all, wouldn't even reach the Supreme Court. It would take at least 2 or 3 years to reach the Supreme Court. So by that point, what will the justices, who will the justices be on that court? Will they still be this conservative body, or will it be a more liberal body? So these are all considerations that are going to be part of making the decision. And that's why it's important to pursue your claim no matter what, because you cannot determine what will be the result of your claim. There's so many factors. And again, as much as the US would like to say that its judiciary is a completely separate branch, it's not. We have elected judges. We have in different states, we have appointed conservative or liberal judges on courts. So the most important thing is, when you find an egregious human right claim that you believe is worth pursuing, where you believe it's grave enough, pursue it. Don't focus on who is the justice, which court, which justice is going to be hearing this case in the federal court. Is it going to be a conservative judge, or is it going to be a Democrat one? Just go forward, because that's something that nobody can determine. And it's more important that your claim is actually hitting the record, that's actually being put on the books in the US. It's going to bring publicity to the crime, and it's also going to perhaps initiate other claims that are similar to go forward. And even if the time frame of the judges being not specifically of a party that would support you, it doesn't matter. That's irrelevant. It may allow in the future a similar claim like yours to go forward, the precedent set. So I'm happy to make links to human rights groups and to the law firms. So the next bunch of cases that we're going to be looking at are in the torture statute. I'm going to start with a discussion of the torture statute. We unfortunately now only have about 15 minutes. So it might be a better idea if I just start and discuss a little bit what the torture statute is and what are the limitations to it. And maybe if we continue that next week, but maybe leave, Victor, you can tell me, I mean, if we've already starting to get some questions